Good evening. I'm John Henry, Chairman of the Committee for the Republic. Today is our Constitution Day, a very appropriate day for the subject at hand. July 1st, 2024 is a day that will live in infamy. The Supreme Court drove a stake in the heart of American constitutional exceptionalism. The rule of law was overruled by the highest court in the land. The court wrote the epitaph for the crown jewel of the U.S. Constitution, separation of powers that denies unchecked authority to any person or organ of government. In Trump versus the United States, the Supreme Court summoned into being presidential power to run roughshod over the law with impunity. Who knew former President Richard Nixon was a prophet in telling British journalist David Frost, quote, "Well, when the president does it, that means it's not illegal," close quote. Who knew the prescience of the constitutionally challenged Donald Trump when he proclaimed as president, quote, "Then I have Article 2, where I have the right to do anything I want as president," close quote. Why, how and why did this happen? Since the Spanish-American War, the Democratic and Republican parties have traded liberty for empire, the march of the mind for the march of the foot soldier. The trade has proved worse than the Boston Red Sox trade of Babe Ruth to New York Yankees. A warfare state that empowers the president to play prosecutor, judge, jury, and executioner to kill any person on the planet based on secret suspicion that the victim might become a national security threat. A surveillance state that targets the not yet guilty without warrants to cow citizens into docility. A secret government that mocks government by the consent of the governed, by crucifying transparency on a national security cross. A Congress that has become a poodle to the executive branch. No one apparently sees the elephant in the room, our epidemic of constitutional illiteracy at all levels. George Washington would have stormed out of the Constitutional Convention if a delegate had proposed presidential immunity from criminal and civil prosecution. Power no longer follows the law. The law now follows power. We have an empire which necessitates a Caesar, and the Supreme Court has crowned the president with limitless power.
Thank you, John, for those opening remarks. They signed their own death warrants. The date, July 4th, 1776. The place, Independence Hall, Philadelphia. The 56 signatories to the Declaration of Independence were steeled by Aristotle's wisdom that courage sits at the summit of virtue, because without it, no others are possible. The 56 gave and risked that last full measure of devotion to secure life, liberty, and the pursuit of happiness. Government by the consent of the governed. Notwithstanding Winston Churchill and the Battle of Britain, never in the annals of history have so many owed so much to so few. Judge Michael Luttig, our featured speaker tonight, would have added his name to the 56, the most sacred band of death. He is made of the same wise and courageous stuff. He has defended the Constitution fearlessly after it was taken off of life support by the Supreme Court in Trump versus United States, coronating the president as a king above the law. Michael will explain with clarity and impeccable scholarship. Now, I leave you with this very alarming juxtaposition. In 1763, well, the American Revolution was gathering speed. The words of William Pitt the Elder thundered like an anvil, a hammer on an anvil across the Atlantic seaboard, summoning colonial resistance to odious British resistance. And these were Pitt the Elder's words, quote, "The poorest man may in his cottage bid defiance to all the forces of the crown. May be frail, the roof may shake, the wind may blow through it, the storms may enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement." Now let's leap forward over 250 years. July 1st, 2024, within our recent memory. Justice Sotomayor declares, without dissent from the Trump majority, the president orders SEAL Team 6 to assassinate a political opponent, immune. Organizes a military coup to hang on to power, immune. Takes a bribe for a pardon, immune, immune, immune. Ponder that juxtaposition. Now, Judge Luttig is a very rare eminence. He has scaled the commanding heights of power and prestige without succumbing to Faustian bargains. He is truly a man for all seasons that we are proud to host. And let's welcome him with an ovation.
So tell us about Trump versus U.S.
Well, I don't think there's anything left for me to say. And that's only half tongue-in-cheek. But it's an honor for me to be here to speak to this particular group and to be with these two men in particular. It's barely overstatement, if any, to say that if you came tonight to hear from our founding fathers and the framers of our Constitution, you have already heard from the founding fathers in the comments made by John and Bruce, and I mean that. I'm just a judge, and worse than that, I'm a former judge. I am unapologetic about the fact that I do not have the command of the Constitution and the eloquence of these two gentlemen to my right and left. I was an apostle to Bruce Fine 100 years ago, and now in many ways at the constitutional level, my life has come full circle that I sit here tonight, you know, next to this great constitutional mind. But thank all of you. Where to begin?
Well, we started with the Colorado decision, which we thought was the worst decision in a long, long time. And then we had the July 1st decision.
I know where to begin, John.
John, was that the 9-0 decision? Was that the 9-0 decision against Judge Luttig?
So let's begin here. For almost 250 years, since the founding. The principle of America, the principle of our Constitution has been that no man is above the law. Hours after the Supreme Court decided Trump against the United States, I wrote these words: no longer can it be said that in America no man is above the law, because today the Supreme Court of the United States held that the President of the United States is above the law, and not just any President of the United States, the former President of the United States of America. The Founding Fathers and the framers of our Constitution, I believe, had they ever thought that the Supreme Court of the United States would hold that the President of the United States is above the law, that they would have literally changed the words of the Constitution in its formation of the Supreme Court of the United States. I do not have any doubt whatsoever. So clear is the palpable wrongness of Trump against the United States. We know that that decision was written for one person, the last person in all of American history for whom that decision should have been written. How do we know it? We know it in 10 different ways, from the opinion itself, coupled with the constitutional manner in which the Supreme Court is required to decide cases, and for 237 years has decided cases, right? As Bruce has said over and over, you know, what about standing? Whatever happened to the fundamental principle of judicial decision making, that a court, any court, but especially the Supreme Court of the United States, decides only the narrowest issue presented to it for decision. Not only that, but Bruce and I in particular have been students and scholars of the presidency and presidential power under the Constitution of the United States for our entire professional careers. And listen to what I say right now. Never in 237 years, never, not once, has any person, let alone any student or scholar of the Constitution, let alone any federal judge, let alone a Supreme Court justice, had ever even suggested that the President of the United States would be immune from prosecution for any crime against the United States of America, let alone for all crimes against the United States of America. Never, to my knowledge, not one person since the founding of our nation before Donald Trump, who is accused by the United States of America of committing what I have called perhaps the greatest crime possible for an incumbent president, argued to the Supreme Court of the United States that no president should ever be liable for any crime that he or she commits. And our Supreme Court of the United States bought it hook, line, and sinker, every single argument, without even thinking about it. So how did their opinion read? It read to the word as if the Supreme Court had no earthly idea what the Constitution says. None. Had no idea about the founding of this country or the debates, the great debates at the founding of this country and around the ratification of the Constitution of the United States. And so, of course, they cited none. Of course, they decided none. What did they cite? Donald Trump's argument that no president could possibly perform the duties of the presidency of the United States if they knew that someday they might be held accountable by the people of the United States for crimes against America. That was the essential reasoning, and he will tell you this, of the Supreme Court. When Donald Trump made the argument, every single person that I know of in America familiar with the Constitution said, this is preposterous. And all of us, think of this, when the Supreme Court took the case, thought, okay, the time has come for Donald Trump. The Supreme Court is going to say what the Constitution says. No, sir. You are not above the law. You, like every president, you will be held accountable for crimes against the nation that you led. And a few months later, imagine the moment the case came down, I called it an abomination. I thought about calling it a constitutional abomination, and I decided no, it's an abomination. The lesser included offense of the opinion was that it was a constitutional abomination. And of course, as if to add insult to profound national injury, individual members of the court at argument, had the audacity to tell the American people that they weren't interested in the particular facts of this case because they were deciding the case for the ages. That is supreme arrogance. There's no other word for it. That is the height of judicial arrogance that the Founding Fathers never actually contemplated as possible. Let's start there.
Michael, could you comment upon this? Just add a little bit of history from my perspective. I was at the Justice Department in 1973, the Saturday Night Massacre. And I remember that Archibald Cox, is my professor at Harvard, he had been appointed special prosecutor at the insistence of Congress, and his task in the charter was to investigate what? Crimes by the President of the United States. And it was the reason why Nixon fired him, because he worried he was going to be prosecuted as President of the United States and there wouldn't be any immunity. That's why he fired him. Then we can take another snapshot of history. Once he did leave office under an impeachment cloud, Gerald Ford and President Nixon both believed he could be prosecuted by Leon Jaworski for the cover-up crimes in the Oval Office. Right when he was right there, he's talking to John Dean. This is part of the evidence. You can't argue this was not a presidential act. He's talking about it as part of his presidential duties. And I was there at the time in the Justice Department. Oh, I was against the pardon, but, well, we need to give him pardon because otherwise he could be indicted. Why would he need to be indicted if he was already immune? So I give these historical examples to show how wrenching this decision was from very, very recent history. Even when Nixon said to Frost, when the president does it, that means it's not illegal. People were shocked. They laughed at him. Are you kidding me? Now he's shown to be a prophet, like Elijah, in the Old Testament. I mean, it just shows you how accurate Michael is in describing the abomination.
And I would just add to that historical litany to make it current almost to the day. It was Mitch McConnell who said, in defending his vote, that America shouldn't worry. Why? Because we all know that Donald Trump will have to answer for any crimes that he's committed. Again, the point is, take it on faith from Bruce and I, but double check it yourself. I am aware of not one single person who had ever even suggested it until the Supreme Court held it almost 250 years after the founding. It's let's dive a little bit into the argument itself. Just like with the 14th Amendment case, I was listening to every word to consult with one of our great journalistic media, and I kept. By the way, what I should tell you, in the interest of full disclosure, is that another one of my clerks, former clerks, actually argued that case too. So of three of my clerks, before Bruce interjects this, I'm going to get out ahead of it. My one clerk, well, my first of four clerks was central to the congressional effort to overturn the election. That's Senator Ted Cruz. I guess the first of my four clerks was the principal architect of the plan to overturn the election, John Eastman. And my other two clerks argued the two cases in the Supreme Court, Jonathan Mitchell and in the D.C. Circuit, I'll think of their names. And they're very, very smart people, by the way, and Donald Trump is very, very lucky. And but in the argument, it was chilling to listen to the questions from the justices. There's no other word for it. Just like it was in the 14th Amendment case. But in the 14th Amendment case, you'll remember, as I said about that case, the argument in that case, the court just, I think, almost literally didn't ask a single question about the only issue in the case. And so everyone knew, we suspected going in, but we knew coming out that the Supreme Court was never going to decide the case, period. It didn't matter what it took. It didn't matter what they had to say or do. It literally didn't matter, ladies and gentlemen. They were never going to decide the case. And of course they didn't. Fast forward to the immunity case. This small vignette, as you know, the last thing I ever wanted in my life to do was be on television. And I guess, for my misdeeds, the Lord has put me on television. So the day that the court took the immunity case, I had flown to New York for a 40-minute interview with Nicole Wallace, and who's just the dearest person in the world. And though I'm as scared with her as I am with anybody else, but we're started, and I'm sitting there at that glass table, petrified, and she introduces me. She didn't do as good a job as Bruce and John, but nonetheless, I had lost all train of thought listening to the introduction. And then she gets to the end of the introduction, and I sober up, and I look at her, and she looks at me and pauses, and it's almost as if she touched her ear and waited a second. Then she said, "Ladies and gentlemen, the Supreme Court of the United States has just taken the immunity case for decision. Judge, this is a curveball, I realize, but you seem to handle all the curveballs up to now. What are your first thoughts?" And I just looked down, and then I looked up at her and into the camera, and I said, "Nicole, there was not a reason in this world for the Supreme Court to have taken this case. Now that it has taken the case, it's exceedingly unlikely that the former president, will be tried before the election, if ever. I'll tell, for the fun of it, so you know how these things work. After the show, she said, "Come back and we want to talk to you about all this." And I said, "Well, I want to talk to you about all this." And the lead producer said, "I said, well, does this happen all the time?" He said, "It never happens. It's what we call having the person in the seat at the moment." And I said, "So well, what did you do?" And he said, "Well, Judge, here's what we did. We knew that this was hitting you cold. And we were just sitting there, fist clenched, 10 of us going, okay, please give it to us." And he said, "And you did?" We all cheered, and I told them to cut those words out and get them around the world instantly so that they would have the first take on the Supreme Court. That's a digression I apologize for. But in that argument, it was astonishing to anyone that knows anything about the Constitution, the questions that the justices asked. As you remember now, they were really straight from Donald Trump's brief. You know? We all knew that something very, very bad was afoot in the Supreme Court. And then to bring this story to a close, we found out what was afoot in the Supreme Court this week or weekend with the New York Times piece. And I know Bruce wants to get into it, so I'll just lay the foundation, as it were, and remind any of you who didn't see it that the New York Times reported that it was the Chief Justice, John Roberts, who had taken the lead in all of the Donald Trump cases, and in the immunity case, had written a memo to the conference, they call it, in which he said, among other things, that I believe we will see the separation of powers issue very differently than did the Court of Appeals. And then, just to show you how comfortable I am with being corrected by this man, I'm going to say, even after thought, I did not see it as a separation of powers issue at all. At all. What on earth are they doing up there? And then I just thought of the best way to close that story out. Right before I came over here, someone sent me I don't even know what a meme is, but I think this is a meme. And if it's not, don't worry about it, okay? They sent me this meme that was a picture of some of the founding fathers. It kind of, at a glance, looked to be Madison, Thomas Jefferson, George Washington, Madison. And one of those thought bubbles, or whatever you call it, coming from them read, "What the hell are you people thinking down there?" And so my main contribution tonight, Bruce, is that meme should have read, "Supreme Court, what the hell are you thinking?" So.
I think if you compare Trump v. U.S. with Nixon v. U.S., where the court did not view that as, they just said the judicial branch needs the information because they're a separate branch that does criminal justice. And so Nixon loses. They didn't write for the ages. This is a simple question here. Can the president be forced to give evidence in a criminal proceeding. Well, of course, how else can the judiciary do its job unless it is subject, the executive, to giving information that's needed to discharge an Article III function? And that was the same reasoning that was used in the, at least they didn't actually indict Bill Clinton. Ultimately there was a settlement, but he was under investigation for criminality. And he ultimately struck a plea bargain. But there, the court was very clear. You can't just decide you don't want to give information because you're the president. He got a fine of $90,000 and was held in contempt by a district judge. The other thing that's unusual is that, as Mike was pointing out, there had been not only no judge in the United States of America until Trump v. U.S. had ever even insinuated that there was immunity. There was no division below. Thousands of judges all had the same view, from the right to the left. Why are you taking this? There's already a consensus. There's the need to even grant review? Then the additional curlicue here, it's typical when the United States Supreme Court takes a case involving the president, they accelerate the process. Youngstown Sheet and Tube, the Pentagon Papers case, the Nixon tapes case, they accelerate it. They understand the need for speed, right? And they're able to chew gun and walk at the same time. This case, they actually asked for accelerated treatment, and the court said no. We just stick it on a regular docket. Waited to the very end of the term, the very last day.
2 months before the end of the term, the court, granted the case.
Yeah.
Heard argument. So let's talk a minute about this pointy-headed legal point. The most fundamental point to constitutional decision-making that there is, namely that the Supreme Court of the United States decides only the case that's presented. So what did that require in this case? That the Supreme Court decide only can Donald Trump be prosecuted for the constitutional and statutory offenses with which he was charged by Jack Smith, all of which related to the former president's effort to overturn the 2020 presidential election. So this is now I'm going to tell you why I've said what I have said for 4 years and leading up to this abomination by the Supreme Court. It just so happens it's inconvenient for our Supreme Court that Donald Trump committed, as I said, perhaps the gravest offense against the United States possible by attempting to remain in office against the will and the vote of the American people. By the way, that's, as I think we may have talked about before, that is in violation of what's called the executive vesting clause, which is just the simplest clause in the Constitution possible. And it just says, a president is elected for 4 years, after which he surrenders his office to his successor, who has been elected by the vote and the will of the American people. But now think about what Donald Trump did. He didn't simply try to stay in office, right? In attempting to stay in office, he also deprived his successor, who had been elected by the American people. He attempted to deprive his successor of the rights, privileges, and the powers of the presidency of the United States, to which he had become entitled by a vote of the American people. So now, with that, you can begin, I'm sure, to understand the gravity of this offense. Now, imagine this. What would the Supreme Court have said and held if it had decided only that issue? Well, we know it would have said Donald Trump is immune from prosecution for that offense. That was too much for the Supreme Court to swallow. Thank God, as it should have been. So what did they do? They said, well, we're not deciding this case. We're deciding the powers of the presidency for the ages. Read as, we're going to decide the powers of the presidency in all and every circumstance. Not just the circumstances with which we're presented, but forever, for all time, all issues. That's a corruption of the judicial decision-making process. Okay? Just think what the Supreme Court left the United States of America with that abomination. First, as far as the country's concerned, they were left with an answer from the Supreme Court that Donald Trump is above the law and he cannot be prosecuted for having attempted to overturn a presidential election, defying America, defying American democracy, and defying the Constitution of the United States. The Supreme Court of the United States said, look, the President of the United States has to be free to exercise the powers of the presidency to the maximum extent possible, even to the extent that he can never be held liable for crimes. So I don't know. I checked out, okay, after that opinion. I said, I was careful even in that moment, Bruce, but I said something like, I cannot imagine that the prosecution can go forward.
If I could just interject, one of the reasons why I don't think it's possible, maybe 2026, that they'll ever go to trial is because in procedural matters, the Supreme Court said anytime you make an immunity defense, you don't go to trial and then appeal afterwards. You immediately go up on review. So whatever happens in the district court here, in the District of Columbia on this issue, it'll go immediately to the Court of Appeals, probably en banc review, because the standard that the Supreme Court laid down is so vague and it's never been done before, so everything is tabula rasa. And then it'll go back to the Supreme Court again. It'll be 2026. And it's all these immunity issues. And one of the things, to me, what showed how corrupt the decision was the court did address this particular vignette that occurred on the morning of January 6th between Vice President Pence and Donald Trump. There was no ambiguity about what was going on. This is Mike Pence, his vice president, a loyal Republican. He's not code pink. He's not getting paid by George Soros. And he says, Donald Trump told me I needed to choose between him and the Constitution when he went to count the electoral votes under the 12th Amendment. Now, is there anything clear that this can't be a presidential act? The president has no role in counting votes under the 12th Amendment. And yet the court refused to say, no, that wouldn't be immune. That to me is flabbergasted.
And indeed suggested strongly, well, actually, I think, correct me if I'm wrong, said there can be no inquiry into those discussions between the Vice President and the President of the United States. That raises maybe the best point of all, which is the extraordinary efforts, in the opinion, that the Supreme Court went to ensure that Donald Trump would never be prosecuted. That's one of them. The others, you know, and there are several, but and I'm gonna let Bruce develop it more specifically because he'll do better. But in a breathtaking paragraph or two in the opinion, the Supreme Court said, "Oh, and by the way, of course, evidence of official acts by the president can never be introduced to prove that his actions were taken in his unofficial capacity." Now, the real lawyers, just regular lawyers and also constitutional lawyers, when they read that, they were breathless. There is no reason in this life for the Supreme Court to have drilled down to that extent, except to ensure that this president would never be prosecuted.
Yeah. I mean, under that theory, Nixon couldn't have been prosecuted for urging obstruction of justice and perjury in the White House, the tapes with John Dean. Why was he worried? No one conceived. He wouldn't need the 18.5-minute gap, right? Of Rosemary Woods, remember that, those who followed the Nixon trajectory. We don't need to erase it. It's already immune.
So let me turn the tables on you, because I just thought of this. Would Nixon have been immune from the Supreme Court's holding that he had to turn over the tapes under Trump against the United States?
I assume what he would have argued is that it's a presidential act you're asking to interfere with, namely interfering with my tapes of the conversations. No, you can't force me, because in the future I might not make tapes anymore, and that could hamper my ability to run for office.
I agree. I agree with that. I agree with that.
I mean, it's really truly astounding how far, the court was willing to go. Especially when, if you look at the faithful execution of the law provision of Article 2, Section 3.
Let me just stop right there.
Yeah.
The faithful execution of the law.
And this was borrowed by the framers, because King James II, who the British Parliament hated, was not enforcing the recusancy laws. Parliament said, wait, that's not going to happen anymore. You cannot enforce the laws that we enact. So in one of the provisions of the English Declaration of Rights in 1689, it said that the king has no power to refrain from enforcing the law without the consent of Parliament. That's borrowed over into our Article 2. This decision on immunity says, well, no, the president, it's optional whether you faithfully execute the law. Really? Optional provision?
So bribes in exchange for pardons. No question. Protected. Here's one for us. I mean, at this point, everything that I hear from Donald Trump's mouth is surreal. But one of the latest, of course, is, unapologetically he will exact revenge and retribution against his political enemies when he's reelected President of the United States of America. Immune? Yes.
Yeah.
And the Supreme Court knew it.
So where did this concept that we needed an energetic president come from? You know, Madison sold George Washington on the Constitution, and Hamilton was could do what 10 other people could do during the war in terms of writing letters. And once it was decided we were going to go to Philadelphia and do the Constitution, Hamilton, was left. He left it because he wanted the
He went a lifetime
Senate,
presidency.
lifetime president. He wanted the senators to be the House of Lords, and he wanted the English Constitution. He was left out of the Constitution. He left, but he was a great writer. He was very efficient, and Washington said, "We got to get this thing done." And then Jay, they were going to write these Federalist Papers, and then Jay had issues, personal issues. So and I don't think this is the word energetic didn't come from Madison. It came from Hamilton in the Federalist Papers. Bruce can tell you which one.
Well,
but the concept of an energetic, I don't think Madison could have edited. He didn't have the internet. He didn't have it, send it over. And Madison, if they'd had the internet, he would have struck the word energetic. But the notion that the president has to be energetic is he cites Fitzgerald, and he makes a big deal out of this energetic thing, and it's so.
But even Hamilton was very ambivalent, because in the Federalist Papers, in two respects, he says on the Commander-in-Chief clause, he says that really it's Federalist 69 if you want to read it. He says really Commander-in-Chief is nothing. He's just head of the armed forces. He can't raise armies. All this belongs to the Parliament. He's not like the King of England. He underscores that repeatedly. And then when it comes to the treaty power, he says, listen, we can't give unilateral power to make treaties like the British king because they can't be trusted. They'll go ahead and corrupt the process for their own personal ambition. So that's why it's really important to get the Senate. So there you have Hamilton, that's Federal 75. There you have Hamilton expressly voicing doubt about having an unconstrained president, saying he would destroy the whole system. And it shows how even Hamilton, who's the most vocal in favor of a muscular presidency, couldn't have conceived this. I mean, it's kind of, if he couldn't have, then it's impossible to think anybody else would have.
But in other words, an energetic presidency never equated with a lawless presidency.
Yeah.
That was the very reason that we sought our independence from the crown and
Right.
the king and the monarchy, right?
Right.
We subjected our king, the President of the United States, to the laws and the Constitution for 237 years. But I've said for, over and over for the past couple years that, really hearkening back to Bruce and John's intimate familiarity with the Founding Fathers and the Federalist Papers, that our Founding Fathers and the framers of our Constitution feared most of anything at all when they were creating this nation, this moment, and this man. And now, I guess I would have to add this Supreme Court in its decision of the issues involving this moment and this man.
Yeah. I'd like to follow up on point you were making about the court, instead of deciding cases or controversies like Article 3 specifies, they were writing for the ages. Because you could see how difficult it would have been if they confined their analysis to the particular allegations in the indictment and said, these and nothing more are what we're examining. We don't have to decide whether there are any other presidential acts that were immune, because this indictment is limited in what is alleging and what laws are violated. And they knew that they could not write an opinion says, yeah, a president of the United States can do this stuff with impunity. And the headline, Donald Trump can summon fake electors to corrupt the process. He can threaten the life of his vice president in order to prevent the counting of electoral votes. They knew that wasn't going to fly. So they elevated the issue to 80,000 feet and said, well, we're just kind of setting parameters out there. We're not deciding anything. All sorts of issues that weren't even presented. Because if they just looked at the facts themselves, they knew they couldn't write the opinion they wanted to.
I could never, in good conscience, let alone good constitutional conscience, have written that opinion, leaving up to a federal district court to take the first cut at whatever the difference is between official acts and unofficial acts of the President of the United States of America. Think about that for a moment. Talk about an utter failure in obligation for the Supreme Court of the United States in this particular case to announce for the first time in all of history, without any foundation, no support, no evidence, nothing in the Constitution and laws of the United States or the history of the, since the founding of the country, announced that we have decided that the President of the United States, cannot be criminally prosecuted for official acts of crime against the United States, though he can for unofficial criminal acts against the United States of America for the first time ever, and then says, you know what, we're going to remand to the federal district court to sort all this out. That is an abject abdication of constitutional duty by the Supreme Court of the United States, and they knew it.
Yeah, it said that the Supreme Court's there to dispel confusion, not create it. This turned that doctrine on its head. Because the standard that the district courts and now the Court of Appeals is going to have, it's so vague. And there's no precedent to write on. It's all sui generis. It takes years and years and years. And who knows what this means? And it goes up to the Supreme Court again.
But what we do know, Bruce, you and I and probably many of the people in this room, is that no one knows, and because this arises in the context of presidential power, listen to this, we will never know the answer. What I'm saying to you is that those of us who have lived this for our entire lives know that there is no answer to what distinguishes unofficial acts by the President of the United States from unofficial acts by the President of the United States. Except at the periphery where it doesn't matter. The President of the United States goes out one night, gets drunk, and kills somebody. Okay, big deal. Everyone, with the possible exception of the Supreme Court, would say, well, that's obviously the murder was not in his official capacity, all right? And I'm being slightly facetiously there, but on purpose, to underscore the utter absurdity of what the Supreme Court of the United States did.
Even the distinction, I think, Michael, is obtuse, because the greatest damage can be done when you're acting in your official capacity. You use the military, destroy the whole country, use the NSA to spy on us all. That's the greatest danger to the country, is when you are acting in your official capacity.
Thank you, Bruce. Fine, because that was like the very first thought that all of us remotely familiar with the Constitution thought when the argument was made. I said every single day thereafter, I said, and talking to public audiences that have known nothing about the law or the Constitution, I've put it this way. I said, so let's just think about this. When do we want the president to be responsible and accountable for crimes against the United States of America? First. In fact, it's the only ones that the Constitution really is concerned about. When he's acting in his official capacity, whatever that is, a fortiori, we would have thought before this decision, that's when he's, of course, responsible. So, to adopt Bruce's analogy on a different point, the Supreme Court literally turned everything
Upside down.
upside down.
Right. And what happened to original meaning and
Oh, well,
Textualism, yeah.
thank you,
textualism?
John, for that. So here, I'll tell you what happened to original meaning. It had already happened. This Supreme Court, it chooses case to case whether even to rely on original meaning. And as the Bruin case proved to us, even when it chooses to apply original meaning, it selectively does so to reach the conclusion that it wants. I think, as I told you the last time, some very dear friends of mine asked me to lead an amicus brief in the Bruin case. And I said, I don't really want to. The Second Amendment has never been of great interest to me. And for personal reasons, I didn't want to do it, publicly in that way. And but they said, please. And I said, I will have to do the original research myself because I don't know the answer. And I did. And we wrote the brief and we submitted it to the Supreme Court. It was far and away the single best brief on original meaning. Justice Thomas's opinion, it was grounded in something, but it was not the original meaning at all. Zero. In fact, the day that opinion came out, I tweeted, or whatever I do, I don't know what you call it now, but I said, the only silver lining of this opinion is that it's the death knell for original meaning.
yeah,
And that proved to be prescient.
they made it up.
They just
Made it up.
make it up.
Right.
And they'll abandon original meaning probably explicitly during the lifetime of this Supreme Court because you can't sustain it. The American people are not stupid.
Well, good. Why don't we open it up, and I see we've got some questions here, and go ahead. Say what your name is. And
Yes,
Yeah.
hello, I'm Dr. Elaine Serrao. Thank you very much, Judge Luttig.
Thank you, Doctor.
Again, you're providing such incredible insight along with Mr. Hyman. Yeah, and I have to ask, well, where does this leave us? I mean, are we going to survive being we're not a democracy, even a republic, by our 250th anniversary, given what we have just seen coming forth from the Supreme Court? So where does that leave us for the remainder years? Thank you.
Well, thank you. And the, well, the best that I've been able to say it is this, I'm sorry. The November 5th election is a test of America's and Americans' commitment to American democracy, the Constitution, and the rule of law. And then, of course, some of you may be familiar with the fact that I endorsed Kamala Harris unhesitatingly, in my words, a couple of weeks ago, in a what CNN called a characteristic 5.5-page single-space typed letter. And I won't talk out of school about CNN and my friends there, but they did ask the question. No, and I am going to talk out of school because I'm proud of this, and it's not a negative against them at all. But they said, well, now, before they had seen it, they said, 5.5-page typed letter? And I said, yes. And they said, well, typically, I mean, look, Judge, I mean, typically that's, of course, not what's done, but more relevantly, people are not going to read a 5.5-page type letter. They don't even read a sentence or two unless we just put it on the screen for them. And I want all of you to know, I proudly said, I don't care. I said, I'm not writing this letter for anyone to see or read. I am writing this for history because this is what I believe must be said by someone at some point. And if that someone at some point is 50 years in the future, I'm fine with that. And I sincerely was. I didn't care.
Let me add a couple of observations. One, what you've remarked was anticipated by Benjamin Franklin when he exited the Constitutional Convention. And he was confronted, what have we got, doctor? A republic or a monarchy? And he said, a republic if you can keep it. So he understood that. Now what I did, I didn't write 5.5 single-space pages. What I did is I drafted a proposed constitutional amendment to overrule Trump versus the United States because the Supreme Court said Congress can't fiddle with this. No matter what they try to do, it's enshrined in the Constitution. They at least approached a couple of senators, at least they have that. Now, the amendment process has been used rather frequently to overturn Supreme Court decisions. The very first one, 11th Amendment, Chisholm in Georgia. With 14th Amendment overruled Dred Scott versus Sanford. We have the Income Tax Amendment, the Amendment Enfranchising Women, and then we have the 26-year-old Voting Rights Amendment. So there's nothing irregular about amendments overturning Supreme Court decisions saying, we think you got it wrong. But it's a long process. You need 3/4 of the state legislatures and still 2/3 of the House and the Senate, and with have a divided, it may take a while. But at least it's a platform to, I think, make the points that were in your single space. So we still have to participate. The only thing that can save us, in my judgment, we have to stick with process. We can't just say, the heck with it, and abandon process. As bad as the Supreme Court decision is, we can't just say, okay, let's pick AK-47s and we'll pick and choose which decisions to obey. We're done. They'll cure worse than the disease. There is a process. It's slow, can work. We have to convince people. Not everyone's going to agree. Certainly, many in this office, this audience here, may not agree. That's their entitlement. That's how civilization works, through debate and reason. And we have a process still at work. It's called amending.
So I want to, add a footnote to that, Bruce. It's not that simple. If for no other reason, then the former president continues to this day to defy America's democracy, the Constitution, the rule of law, with respect to January 6th. And if he's elected, of course, he will never be prosecuted for those grave offenses. And if it were ever attempted, he has the immunity decision from the Supreme Court, which brings me to the point I've been making for 2 years now, 3 years now. The United States of America will never again be the same envy of the world and the beacon of freedom and democracy to the world that it's been for almost 250 years. It's not possible. I mean, just all of us can understand what the world will say from this day forward when we proudly proclaim, that we are the bosom of democracy and freedom. They go, really? Well, what about Donald Trump, who drove a stake through the heart of American democracy and succeeded, as he drove the same stake through the Constitution of the United States and the rule of law with the imprimatur of your Supreme Court of the United States. So what are we going to say?
Let me just contrast that description of the reaction abroad to Nixon versus United States and then his resignation. I have confronted all sorts of Europeans. How could you do this? He was the most powerful person in the world. That could never happen in our countries. They were awed. I mean, this is the one. He took off the helicopter from the White House lawn. How could that happen? He said, yeah, that's what makes our country great. But they were truly stunned because none of them thought it could ever happen in their countries, only in the United States. You're saying, not anymore.
I just don't understand why we have to accept the decision of these extraordinarily minor corrupt characters on the court. Bruce has a solution, which is the amendment process. If the Democrats win, is there not, I'm curious from your point of view, is there a movement among the judges to say we have to change this court? This court cannot continue to have decisions like this. No, the British formed a court a number of years ago. They didn't make the same mistakes with these perennial seats. Is there any movement abroad, afoot, to change the composition of the court?
No effort, ma'am, that will ever go anywhere, okay, on changing the composition. I think that someday it might be possible that we would have term limits. But again, the answer really to all of these issues, including the amendment, is American politics. Understandably, under the Constitution, you know, it's a political decision by the American people, but first by our representatives.
Yeah.
There's not a chance in this world that any of these changes will be proposed by the polarized politicians that we have today and that we are promised to have in the near future for sure.
Yeah. And I want to respond in particular to the question by referencing Abraham Lincoln's inaugural address, where he was confronting Dred Scott versus Sandford, which he had inherited from 1857. And he said, as bad a decision as it was, we can't just tell the Supreme Court to jump in the lake. It's not a ruling for the politics, and he had statutes passed that acknowledged that blacks could be citizens, and then ultimately we have the 14th Amendment that overrules it. And it was because Lincoln said, the consequence of being able to pick and choose what judgments to obey or not, it's a cure worse than the disease. There's no limiting principle. I know it's hard to swallow when you think it's really a terrible case. And that was Abe Lincoln, and he had to live with Dred Scott versus Sandford. And ultimately, we did get an amendment. It wasn't immediate, 1857 to 1865, the Anti-Slavery Amendment, 1868 was the 14th Amendment. But politics works slowly. But it is true if the politics doesn't change. But the politics is us. The politics reflects the citizens. And that's why when John and I met with Thomas Massey from Kentucky, he said, Bruce, why are you blaming the Congress? Who are the citizens keep sending these people back? And if I talk to my colleagues and my constituents about the Constitution, it's like speaking Shakespeare to cows.
John, we'll get you and then Bob. Okay.
Hi, Diane Perlman. What do you think was the process going on between them in this? And if they were afraid, who was afraid of revenge, and what did they imagine, or what kind of revenge could it have been? And do you think they had a crisis of conscience, or feel guilty, or will confess on their deathbed, or what?
So on the 14th Amendment case, I was confident that it was literally fear of interpreting the Constitution and disqualifying the former president from running for the presidency again.
What were they afraid of for themselves?
I think that they were first afraid for themselves and the institution, and then they cast it effectively as fear for the country. That's when they were making the false claim that I called out in front of the whole country, that disqualification is anti-democratic. And I said to the Supreme Court and to the country, no. It's the Constitution that tells us that the conduct of engaging in an insurrection against the Constitution of the United States is what is anti-democratic. And therefore, the person who engages in that anti-democratic conduct must never hold high office again. The Supreme Court, of course, continued to say up to and through its decision that no, actually, that's just wrong. The Constitution, be damned. We know what's anti-democratic, and what's anti-democratic here is to disqualify this man from holding high office. Now, on the immunity decision, you know, what was at work there, it's mystifying, but it really isn't. You know, we know from their opinion, and now, you know, from the, you know, the memos that were reported in the New York Times, that the Supreme Court of the United States actually believes what it wrote, and believes what it wrote with respect to Donald Trump. The immunity decision was Roberts, but the New York Times reported that Roberts, the Chief Justice, also wrote the per curiam opinion in the 14th Amendment case.
Thank you, Judge. Another very brilliant discussion. I would quarrel with your assertion that the Supreme Court in its immunity case said that the president was above the law. And I think you drew away from that towards the end when you started talking about the whole, the issue of the distinctions between official acts and unofficial acts. And I think that's what they were talking about. Secondly, and we got into this with Bush, I mean, not with Bush, but with Bush, we actually have a president now that's out of control, a presidency that's out of control, where our president can order the U.S. military to roam the world, invading countries, invading Syria, invading Iraq on false pretenses, and nothing, the Congress does nothing, the Supreme Court does nothing because it's a political act. You talked very much about the president's obligation to enforce the law. We have a president in the White House now who refuses to enforce immigration laws. Where does that take us? What are we going to do about that? But ultimately, all of these issues come down to what you and Bruce were discussing, and that is these are political issues. I think the original framers never understood the Supreme Court to be a referee between the executive and the legislature. That was Congress's responsibility through the impeachment process. And it's only through the years, the last 200 years, that the Supreme Court has accreted more power to intervene in the affairs of the states and the affairs of the federal government. But otherwise, brilliant discussion. Happy to be here.
Yeah, well, it would take us all night to unpack all of that, and we would, it would be messy to unpack. But on your first point, if I said the Supreme Court actually held that no man is above the law, I'll retract that. What it said is, we do not hold today that no man is above the law.
I want to also make the observation, Bob, that the reason why...
I'm sorry.
I don't think it said that either.
No, it did.
It did not.
What did it say?
With all respect, what it said, and it was at pains to say, is that it recognized the principle that no man is above the law, and assured the country that it was not holding differently. That's the real problem with those words, because it actually did hold that. And then just briefly, you know, we obviously have a very different views about the current president. But as far as I'm concerned, the only issue that I'm addressing tonight is palpable illegality by a president of the United States of America. I hope, sir, that you're not suggesting that the current president has in any respect at all violated the Constitution of the United States, because if you are, you simply have no basis whatsoever for that.
Suggesting he violated the obligation to enforce the laws with respect to the immigration laws, which he has basically decided not to enforce.
Well, I won't necessarily address that immediately. The larger issue that you raised about the court not being the umpire between the executive and the Congress was because they actually thought they had given birth to a Congress with a vertebrae, a spine, that would defend its own powers. And it did, early on. When President Washington issued a neutrality proclamation, which had criminal penalties in it, juries wouldn't convict, and Congress said, no, you can't create crimes. It passed the Neutrality Act, that we decide what's to be made criminal. And so that the court doesn't need to intercede if Congress is defending and exercising its own prerogatives. The only time these arise, it has risen more recently, is Congress doesn't do anything anymore. They're very, very docile. Let me give you this one example to show how far we are from the original understanding about powers and the extraordinary duty that all three branches felt required them to stick within their proper domain without any court order. In 1810, the Senate was upset that the British and French were intercepting our maritime commerce as part of these Napoleonic Wars. They passed a statute when Madison is in office, said, let the president decide he can go to war if he thinks it's needed to protect our maritime conference against violations of neutrality by Britain and France. Madison said, you can't give me that power. You have to decide. He had a son-in-law who was in the House. So Madison called his son-in-law, you need to kill this in the House, and it was. Now that is inconceivable today. A president going to Congress, you can't give me that power. It can't happen. So the reason for some of these litigations that you're correct, Bob, weren't anticipated at the framing, because they thought the branches would be defending their own prerogatives. Congress is throwing them out.
And by the way, just thinking, the one thing we know about the otherwise inexplicable statement by the Chief Justice in the memorandum to the conference prior to argument, that I think we will disagree with the separation of powers analysis by the Court of Appeals, is this. This Supreme Court believed that it is its responsibility to adjudicate the disputes between Congress and the executives. Now, I happen to agree with that general principle, but I think it's possible that the Chief Justice was saying that we will disagree with the separation of powers analysis of the lower court between the executive and the Congress. That is, the Congress cannot criminalize any conduct by the president. Don't you think that's probably what he was referring to?
Yes,
Yeah.
for sure.
And so we know to a certainty the Supreme Court doesn't adopt your view of the adjudicability, if you want to call it that, of disputes between the Congress and the executive.
Yeah, and I remember, you may recall, Michael, John Yoo, after 9/11, he wrote a memo. Obviously, the position taken was that Congress could not prohibit the president from engaging in torture, because if he thought torture was an instrument of war, he had limitless power to decide anything he thought was appropriate to win the war, locking us all up, deciding that we couldn't have elections anymore, dissolving Congress. Hey, it's war power. Everything is subordinate to the war power. I said, wow. And that's John Yoo, who probably is associated with some of your former clerks. But it's really quite, it's amazing.
We had gone an hour or more.
We've run out of time, but
Oh,
Michael.
let's have a couple more, John.
Okay, all right. We can go over.
This is too fun.
All right. Go ahead.
These are smart people.
Maybe not this one. My name is Fred Bonig from the Daily Ripple. I'm a Gold Star dad. But my question is, if I went back in my Wayback Machine on the internet, and would I find a 5-page letter of you talking about how Mitch McConnell stopped Garland from being brought in and how he let Barrett in? Because if that doesn't happen, if those two people weren't in and they had 2 more liberals on the court, we wouldn't be having this conversation at all, right? So did you speak out about that? Because that was the Federalist Society, right?
Yeah, well, I was okay with your question. Are you under the impression that I'm of the Federalist Society?
asking. That's who did that.
Because I've never been to a meeting of, but no, of course you wouldn't find anything like that, but not for the reason you're suggesting. The reason you won't find anything about that or anything else political in 50 years of my writing and speaking is because I've never spoken a word about politics per se. And I'm proud of that, yeah.
Well, how do you feel about those things?
It's irrelevant, and that's why I haven't spoken about them. I don't want anybody, and especially for the past 4 years, I don't want any person in this country to be able to criticize me for anything political, so that they receive whatever I say as pure law and nothing but that.
Yeah. Let me make this observation, that it's true that held up the vote, so it blocked Garland's confirmation probably, but it could have been close. But these kinds of maneuverings, that's not limited. I mean, justices decide when they're going to leave to see who's going to be president when there's a vacancy. These timing issues, you can't divorce the court from politics, because politics is how the justices get there, completely. And was there anything unconstitutional about what Mitch McConnell did? He got reelected. I don't have to applaud it, but that was the process. Oftentimes, a president, if they're willing to expend enough political capital, they could, because the president's agenda is huge, all the money that's spent everywhere in all these districts. It's a matter of how much capital is the president willing to spend to get his judges confirmed. Now, historically, for whatever reason, Republicans have been willing to spend far more capital than Democrats, who haven't been willing to go to the mat. But that's their choice if they want to do other things. And I know that was true when I was serving in the Justice Department with Reagan. The Democrats came in and they didn't seem to have the same fire in the belly. It's just really, really important. But I'm saying that's just one of the political maneuvers that's not atypical with vacancies. You mean blocking a justice from having a vote?
All the way down to the last month of the election? Has that ever happened before? That they held up one for a year because of that, and then they made a new rule and came to the other one?
Well, there have been names set up there, and the Congress never voted at all. They withdrew their names and left because they couldn't get a vote at all. So, I mean, unfortunately, it's more routine than you'd think, the skullduggery that they'll indulge in.
I would like to take this idea of the out-of-control presidency, take it one step further with a what-if question. The presidency now has the Supreme Court decision. So what happens if on November 6th, President Biden decides to order the arrest and charging of Aliato and Thomas for accepting bribes and perhaps someone, and then orders the protective custody of Donald Trump, given the fact that there's been at least 2 assassination attempts on him.
Yeah, sir, the problem with the hypothetical is that it's not hypothetical in that context. Joe Biden and Kamala Harris are never going to do anything like that. Well, not you. No, all of those who want can wish for that, but it's not going to ever happen, sir. And I'm the biggest Republican that's ever walked the face of the. I'm the biggest conservative that's ever walked the face of the planet, right? That's where, if you want to get into political discussion, the Democrats gotcha, because they ain't going to do that, and they know it, and the Republicans know it too.
I can't resist making this observation. The President of the United States can't indict anybody. Under the Fifth Amendment, you need a grand jury indictment. And the President doesn't get to appoint grand jurors.
It's been said
So-
that a good attorney can get a grand jury to indict a bologna sandwich.
Well, that's what some they say, but sometimes they can't get it. If it's made out of nothing, it would be very hard, probably, to get someone to indict a Haitian for eating dogs and cats in Springfield.
So this is
Right? So there are limits. Like, if I could just one thing. There's a very famous opinion by Justice Miller in a case called the United States versus Lee. And he said, if the law had to confront and answer hypotheticals that are born of a fervid imagination, the whole fabric of the law would collapse. So you can dream up hypotheticals of any crazy thing, but the law doesn't need to address things. It needs to be earthbound.
But I just thought actually this gentleman's question is on reflection very, very serious. Not for the reason you think, but for this reason. That is exactly the reasoning employed by the Supreme Court in reaching its immunity decision. So when that was coming up, for instance, what I said to people that I spoke to and who asked the same question you did, I said, you're right. This is the slippery slope, isn't it? And you're right. The next time that a president of the United States attempts to overturn an election that he lost fair and square by the vote of the American people, he might be prosecuted by a Republican president or a Democratic president, which is to say that's not a slippery slope at all.
No. The slippery slope argument was used regularly in Clinton versus Jones as well. Well, if you let the president be sued, there'll be 8 million lawsuits or whatever. There weren't any. You know, the people have no clue all the barriers, at being a practicing attorney, clients or whatever, to filing lawsuits, Rule 11, all these other things. It doesn't happen. All these mad exaggerations. Oh, once the president be sued once, there'll be 8 million lawsuits, and he'll never be able to spend a single day on his work in office.
But in fairness to the questions, that kind of question is being asked nationwide by the Republicans and Trump supporters, the obvious answer is, you know, you're right. Never before in American history has any president done any of this at all. So I guess we do have to change our entire system of government and our Constitution to anticipate that every president of the United States is going to try to overturn an election that he lost fair and square.
John, do we need more time?
Yeah.
Okay, we are over time, so this is the last question.
Our speaker, as long as Michael wants to answer questions, we will.
Talking about the possibility of changing things, one thing that hasn't come up that I've heard much discussion about is the opportunity for an executive, a president, to issue executive orders that prescribe the behavior of presidents, and then the test would be, would the Supreme Court take those executive orders and overturn those if they proscribe certain offensive behaviors that a president might do under the immunity decision?
Yeah, I can't even imagine that any president, Democratic or any Democratic president would ever even conceive of such a silly idea. But I caught myself because, in all seriousness, I believe Donald Trump would do that. And yes, the Supreme Court would eventually have to decide that silliest of questions.
Well, after the decision, I had suggested that President Biden, assuming that he doesn't anticipate he will need the Trump decision, could issue an executive order saying, I waive all immunity. And the court has said as long as the executive order is there, you have to obey them. You could repeal it. And then if Trump came in, he would pay a political price if he wanted to, which he could, revoke the executive order, which kind of be an advertisement, hey, watch me for my next crime. Now, unfortunately,
I don't think he'd pay any price at all.
maybe among his supporters, but it's unfortunate that, in my experience, it's been a long time, and I think, Mike, you'd agree that no matter who's in the White House, who at parties in the White House, all the advisors defend limitless executive prerogative. They push the envelope. It doesn't matter who's there or not. And it's a war power. As an example, when Joe Biden was in the Senate and he was running for the Democratic nomination in 2007, he said, oh, if Bush goes to war against Iran and bombs them, I'm going to lead the impeachment charge. I have no power. He has no power to go to war unless we declare war. Then he becomes president. He sees Libya. That's okay. He says, I can go to war to defend any NATO country on my own. I can go to war to defend Taiwan on my own. What happened? He became president.
Bruce, don't leave this audience with the suggestion that the customary, typical, and to be expected, and constitutionally contemplated pushing of presidential prerogatives is what we're talking about here. It's not. And, you know.
No, it's matters of degree, to be sure, but I
No, it's not a matters of degree
Yeah.
now in this instance.
In the Trump versus United States, correct. But in the larger principle, Michael, it's very, very discomforting. And look at Jackson's concurring opinion, Youngstown Sheehan 2. Say the president, on his own, can just say, I'm going to war. And then because the war power brings along all these others, suspend habeas corpus and whatever.
May we take a question from this
It's not as flagrant, but it's a derivative of the lawlessness
One
idea.
last question.
Okay.
Hi, George.
Hi, John, Bruce. On the case itself, could you address the viability, future viability, value of of what the Supreme Court said about rebutting the presumption that something is an official act? And I'm specifically thinking about the possibility, I don't remember what the court said about it, the difference between committing an illegal act while performing official duties versus accusing the president of performing his official duties illegally. And so how far can a good lawyer take the presumption and drive a truck through it to be able to prosecute illegal actions by a president, even if the president argues they were part of his official
Only as far as
responsibility?
this Supreme Court will let that prosecutor, and it's this Supreme Court that's going to enforce that immunity decision against Jack Smith.
And I want to underscore and repeat, the Supreme Court could not find itself able, despite the clarity of the Constitution, to say, when on the morning of January 6th, Mike Pence was told by the President of the United States, with no reference to the Constitution, choose between me and the Constitution when it comes to counting the votes, it couldn't get itself to say, well, that clearly isn't a presidential act. Not? I mean, that is the clearest example of a totally non-presidential act. The president has no authority under Amendment 12 to count anything relating to electoral votes.
I have no control at this point. In fact, I've never had any control.
You mentioned Jack Smith,
Yeah.
who has a history of being a rabid overcharger. He lost every big case that he's ever litigated. He lost the John Edwards case. He lost the first Menendez case. He lost the Governor Bob McDonnell case and got smacked down 8-0. That was probably a little bit better than your 9-0 decision on the Section 3 case. How much do we have to blame all of this on Jack Smith and the fact that the Supreme Court of the United States hates Jack Smith?
Sir, you just have to, all I can say to you, in all honesty, is you either have to accept our system of government or not, okay?